Good afternoon, everyone. Just confirm if audio and video everything is clear. Those of you who are online, please confirm if audio, video everything is clear, everything is in order. Because of some technical difficulty, we could not start at 2:30 p.m., which was our scheduled time. But we would cover all the content which are supposed to be taught in this class. Okay, thank you, Yogesh, for confirming that audio, video everything is clear. So, welcome to the 6th class of our N100 Polity series. As you know that in this series we are going to cover the complete polity syllabus from mains perspective. What do you mean by mains perspective? Mains perspective means we are going to choose the themes on which a question is expected in the mains. These themes could be some of them static, some of them could be from the current affair as well. For example, in that today's class, the most of the themes that are there, they are from the static part only, the amendment, the basic structure and the emergency provisions. Okay, so in today's class we are also going to cover the emergency provisions. Okay, so I hope that you are coming to the class with well prepared. You have the pen and paper in your hand. Do keep noting the things, and as I have told in the earlier class that you must prepare a compilation of some of the important Supreme Court judgment. And today's class also we are going to see various Supreme Court judgments that has evolved the way our constitution can be amended. Okay, so all the judgments I'm sure you must already be knowing. So I would expect prompt reply from you whenever I ask any questions. So let's start with the first thing, that is that how our constitution can be amended. What is the procedure to amend our constitution? Can you tell me? This is something that every one of us must have studied. What is the procedure to amend our constitution? Article 368. Yogesh is saying Article 368. Anyone else with any other opinion? Article 368, all of you are agreeing that article, there is a dedicated article that deals with this factor. Okay, article number 368. Are we still live? Can you listen to me, or has the video ended? Am I audible? Okay, thank you. There was some issue on my system. It was showing that I am not visible. Okay, so apart from the fact that you have said that there is Article 368 which talks about the amendment of the constitution, there are other ways of amending our constitution as well. There are few provisions of our constitution that can be amended through simple majority. Okay, what is simple majority? The examples include like creation or abolition of states, a state legislative council, if it has to be created or abolished. All these things has to happen through, or rather can happen through simple majority only. Because see, the Article 368 that you are talking about is, it talks about a special majority. And what is this special majority? This special majority includes two things. First is there has to be a 2/3 of the member present and voting, plus majority of total strength. Is it clear, this special majority? How do we calculate this special majority? Or if any one of you have any doubt, you may ask. And this is these are the two conditions must be satisfied, and in both houses separately. Both houses sitting together separately, these two conditions must be satisfied for a Constitution Amendment Act to be passed. Okay. So the important provisions like fundamental right, DPSP, and any other provisions which is not mentioned here in a special majority, or there are few provisions for which we also require ratification by half of the states. What do you mean by ratification by half of the states? So it's like once the constitution, both the houses of our parliament passes this constitution amendment through a special majority, half of the states, we have 28 states, so half of them have to ratify it. Ratification will happen by simple majority in a state legislature. Okay, so which are the provisions that requires this special condition that half of the states should also ratify it? These are the provisions which are as such in nutshell you can remember the provisions related to federal structure of our country. For example, election of president, because both the MLAs as well as MPs take part in election of president. So that's why this is related to federal provision, and any amendment to this will require ratification by the states. Supreme Court and High Courts, division of power, representation of states in parliament, or if Article 368 has to be amended, then also this procedure has to be followed. So anything which is neither falling in this category nor falling in this category would be falling in second category. So most of the things like fundamental right, DPSP, fundamental duty, or any constitutional body, if we have to amend anything about those constitutional body, they will lie in this second category. So there are three ways in which parliament can amend. So it depends on which provision of the constitution has to be amended. Now please answer me a few questions. You have to answer first, second, or third. Suppose I have to, or rather parliament has to amend schedule 5 and schedule 6. Which of these three methodology parliament would have to follow? Schedule 5 and schedule 6 are to be amended. Some amendment are required to be done there. Okay, Yogesh is saying that it would be 3. Anyone else? Prathamesh? Mr. Bhavel? Okay, Mr. Bhavel is saying 2. And the correct answer is 1. So it is written in our constitution itself that to amend article schedule 5 and 6, and that's the reason why schedule 5 and 6 have been written separately, because one purpose was that we have to make our constitution crisp, so all those detailed provisions are there in schedules. The other purpose was also that we if some modification is required, that could be done easily through a simple majority. Okay, this is something which is more relevant for prelims. When we are going to do with prelims, we would revise all the different provisions. In mains, a question will come that parliament has different kind of powers with respect to amending. Only if you know a few examples, that is going to be sufficient. All examples you need not know for mains, but for prelims you must remember all the examples. Now next question is that what are the veto power available with the president with respect to constitution amendment bill? I mean, president has different type of veto available at his disposal. So which of those veto power can be used by president on a constitution amendment bill? Once a bill is passed, obviously it will go to the president for his assent. So what kind of veto can president use? Whether he uses it or not is a separate matter. But what are the powers that the president possesses? Can you confirm if you can read the text on the board, if everything is legible? To hold the bill for assent? That is called veto power, Yogesh. And the answer is that president has, you must write it down right here. The president does not have any veto power, or rather, no veto power. We shall again revise it. The veto power we shall study dedicatedly in the chapter of president. So I am telling you here also, I will tell you there also. I would expect you to remember the things that I tell you once. Okay, in that chapter I will ask you that something I have told you earlier. Please tell me. Okay, so this way we are going to revise certain things as well. So here you must write that president does not have any veto power with respect to constitution amendment bill. If a constitution amendment bill is passed from both the houses, president must give his assent, and this was also added by 42nd Constitution Amendment Act. The 42nd Constitution Amendment Act made it binding on president that he must give his assent if Constitution Amendment Bill is presented to him. Okay. Next is, see, this is the static part that we have studied. Most likely the question is not going to be as simple. The question will link it how the amendment power of parliament has evolved over a time, or how different judicial pronouncement have restricted or changed the power of parliament to amend the constitution. Let's see the doubts that you have. I thought about general bill. No, Yogesh, I was asking about this constitution amendment bill. Ratify कर सकते हैं. President not president gives assent. Assent is the word which is used for president, which in normal layman language we say na president has to put his signature. The constitution use the words president should give assent. Okay, so when it is only after a bill gets the assent of the president, then it becomes an act. So in case of constitution amendment bill, the constitution article 368 itself writes that president must give his assent. If a constitution amendment bill is presented to president, he must give his assent. Okay, so from there we can infer that there is no veto power. The veto power what? If president has the power not to give assent, this is called veto power. Until or unless president gives his assent, a bill is not going to be act. So if president has the power not to give assent, like he is vetoing something, this is something which is not available in case of constitution amendment bill. Okay, so Yogesh is asking under which article other two methods come. See, article 368 mentions about these two provisions, a special majority and a special majority plus ratification, whereas these are mentioned in various different. For example, article 169 deals with a state legislative council, and this article itself mentions that if any act passed by parliament for this purpose will not be considered a constitution amendment. Article 3 mentions about creation or abolition of a state. So the provisions related to this simple majority, they are spread across various articles. Okay, so I mean the relevant article for those provisions, that article specifically mentions that if an act is passed by parliament for this purpose, it would not be considered a constitution amendment. Okay, so from that we come to know about this, whereas these two are mentioned in article 368 itself. Is it clear? Now let's see how this amendment power has evolved. Okay, so this is something, if a question, there can be two different type of questions, and I am merging them together and teaching you in one go. One is how the tussle between fundamental right and DPSP has been settled by various Supreme Court judgments. Another could be how the power of parliament to amend the constitution has evolved through various Supreme Court judgments. I am teaching both of them together because if I teach them separately, there are chances of confusion. The students get confused between various judgments. Okay. So I am going to give you a timeline. Through this timeline, you have to see that how various or other when you try to memorize the timeline, you understand the logic or rationale that was being debated in the court. Okay, so the first thing, yes, Kesavananda Bharati was the culmination, but before that we have to study the evolution. That is also something that can be asked. Okay, the first thing is that we got in 1950, the constitution was made, and this constitution had 7 fundamental rights. The right to property was given as a fundamental right in original constitution. So obviously, people could go directly Supreme Court in case their right to property was violated. Now, the government wanted to do certain land reforms. This year in 2024, in economy, there has been a question on land reforms. Okay. So land reform is also important. Usually with a gap of 2 or 3 year, land reforms question reappear. So 2025, there may not be any question. But in 2026 or 27, there is definitely going to be a question on land reform. And the same question is repeated by UPSC every year. Okay. In case I take economic classes, I will teach that as well. So let's see. Government wanted to do land reforms. For land reform, what was there? That Jamindar had a land, so it was property. That property has to be taken away from him. It has to be redistributed among those who are landless, who are laborer, who are tenants. Obviously, it was considered a violation of right to property, or at least those people who were possessing those right to property, they considered it as violation of their fundamental right. So they definitely approached the Supreme Court and said that this, our fundamental right, is violated. And Supreme Court said that in case, or the government gave an argument that we have a DPSP, and in DPSP it is said that the government should make effort for social justice, economic justice. So we are implementing the DPSP. In this case, Champakam Dorai Rajan versus the State of Madras, Supreme Court said that DPSP are not justiciable. They cannot be enforced in a court of law. So in case there is a contradiction between DPSP and fundamental right, the courts are bound to implement the fundamental rights. So fundamental rights are supreme. This is something that Supreme Court said. Okay. Then the first constitution amendment was passed. And in this first constitution amendment, Article 31A and 31B were inserted. We have already studied this, or didn't we? Article 31B talks about 9th schedule. What is this Article 31B? Let's first study Article 31B. We have studied them when we were studying that the fundamental rights are not absolute. Can you recall what was there in 31A? 31B, I told you, it talks about the 9th schedule. Can you recall what was there in 31A? At least you must turn your pages, look at your notebook and give the answer. Because until unless you revise it, and if you are not able to remember it, write in the side notes that you have to revise the fundamental rights are not absolute. That theme you have to revise today. This is how you are going to do multiple revision, and ultimately you are going to remember all the things. So 31A was about acquisition of a state. So if a state has to do the acquisition of a state, for that purposes a state people's fundamental right can be violated. For acquisition of a state, one cannot approach the Supreme Court for enforcement of their fundamental rights. Okay. Now there was another case in the same year 1951, that was Sankari Prasad case. in this case, the parliament's power to amend the constitution or rather amend the fundamental rights were challenged. The parliament amended the fundamental right itself in 1951. So people approached the Supreme Court and said that parliament cannot amend the fundamental rights. What was the rationale given? See, yesterday's class I told you that no law can be violative of any part of the constitution because we have a written constitution. But specifically for part 3, there is an article 3 which says that part 3 cannot be amended. No law can be violative of article 30 or any provision of part 3. So people argued that in this law also includes the Constitution Amendment Act. Article 13 specifically says that no law can violate any provision of part 3. People argued in the court that in this provision, law also includes the Constitution Amendment Act because this is also an act passed by Parliament. So Parliament does not have power to amend the fundamental rights. The Supreme Court in the Sankari Prasad case said that Article 368 provides a constituent power to Parliament. So Parliament has two different type of power. One is called normal legislative power and another is called constituent power. So constituent power is akin to the power enjoyed by Constitution Assembly. And under this constituent power, Parliament can amend any provision of the Constitution, including fundamental rights. So in this Sankari Prasad case, Supreme Court simply said that Parliament has power to amend fundamental rights. This is also you should write. Parliament has power to amend fundamental right. Okay. But the same stand was changed in the Golaknath versus State of Punjab case. In this case, the Supreme Court took a different view. Supreme Court says that the Article 368 is simply worded as procedure to amend the Constitution. It does not mention that Parliament has power to amend the Constitution. So since it is merely an enabling provision, it does not include the power to amend the fundamental rights. So in Golaknath case, the Supreme Court took a view that fundamental rights cannot be amended. Okay, so this, in the hindsight, this does not seem much logical because you have been given you are told that there is a procedure to do something. It implicitly means that you have power to do it as well. If you come to my home and I give you I show you food and I tell you that yeah, this is a Chinese food, you can eat it this way, does it not implicitly mean that the food presented to you is for you to eat? You cannot say that, oh, okay, I mean the food was not there to be eaten. So, but still this is what Supreme Court interpreted in Golaknath versus a State of Punjab case. Okay, the Parliament said that okay, let's change the Article 368 itself. That's your problem. No? You are saying that this article does not mention that there is a power to amend the Constitution. Amend it and write that power to amend the Constitution. So, through 24th Amendment Act 1971, Parliament amended the Article 308(1). And in this, it was written that Parliament can amend any part of the Constitution. There was this slight mistake. It was not the 42nd Amendment Act, rather this 24th Amendment Act. Through this 24th Amendment Act, the President must give assent. So if a constitution amendment bill is passed by the parliament, the president must give his assent. This was introduced by 24th Constitution Amendment Act, not 42nd. Make this correction in your notes. And they also changed the Article 13. Here, they also changed the Article 13 and they wrote that the law mentioned in Article 30 does not include Constitution Amendment Act. So see, earlier judgment, whatever was the stand taken by Supreme Court in Golaknath case, Supreme Court said that power does not include. So they changed the heading of the Article 368. They also wrote it explicitly in Article 368(1) that President must give his that Parliament can amend any part of the Constitution. And then they also amended the Article 13 that law in Article 13 does not include the Constitution Amendment Act. Is it clear? Is there any doubt? You must ask. Till now, are you able to appreciate the process, how it has evolved? First, there was right to property, because of which people approached the Supreme Court. Okay, government first gave the argument that I am doing it to implement the DPSP. This argument was not accepted. Since this argument was not accepted, court said the fundamental rights are supreme. So then the government brought about a constitution amendment, and it said that acquisition of a state can be done, and if any act is put in the 9th schedule, it can violate the fundamental rights. Okay, then people challenge the parliament power to amend the constitution itself. In Sankri Prasad case, first Supreme Court said that parliament can amend fundamental right, but in Golaknath case, the Supreme Court changed its stance. The argument given was that Article 13 says law, any law cannot be violative, and the second was that Article 368 does not say that there is a power. Okay, so here in 24th Constitution Amendment 1971, Parliament amended both these things. First, it amended the Article 368, and here it was written that Parliament can amend any part of the Constitution. Explicitly, it was written. The second is that it also amended Article 13. Article 13, they explicitly write that law in Article 13 does not include Constitution Amendment Act. In Article 13, it is written that no law can be violative of any of the provisions of this part, that is fundamental rights. Okay, so here the amendment was done and it was written that law under this article does not include the Constitution Amendment Act. So it meant that Constitution Amendment Act can be violative of part 3. So it made the process clear that a Constitution Amendment Act can take away fundamental rights. Okay, so, and it also made another change that even President must give assent to Constitution Amendment Act. Till now, we have reached 1971, and this is something which was done by Indira Gandhi. Okay, in 1971, Indira Gandhi was our Prime Minister. Indira Gandhi also brought about this 25th Constitution Amendment. And through this 25th Constitution Amendment, another article 31C was added. 31A and 31B were added by first Constitution Amendment, whereas 31C was added by 25th Constitution Amendment. Okay, and in this it was written, two things were written. First is to implement 2 DPSPs, 2 fundamental rights can be violated. What were these 2 DPSP? They were the DPSP mentioned in 39B and C. Okay, and 2 fundamental rights which can be superseded was Article 14 and 19. So any act which is implementing Article 39B and C shall not be questioned in a court of law on the ground that it is violating either Article 14 or 19. Originally, it also mentioned Article 31. Because at that point of time, Article 31 was a fundamental right. Later on, when Article 31 was removed, here it is now currently only left 14 and 19. It also said that when an act is declaring that it is being enacted to implement Article 39B and C, it shall not be questioned in a court of law. So, if an act, when an act is passed, it mentions the purpose of enacting that legislation. So, if the purpose is mentioning that the purpose is to implement 39B and C, that is going to be sufficient. That act cannot be further questioned in a court of law that it is not giving effect to Article 39B and C. Okay, obviously this is something which was problematic. Any act can, like for example, today you must have seen that there were a few acts which have been passed as a money bill, although most of us would agree that they should not have been called a money bill. They had provisions which were beyond Article 110. Similarly, any act can write that I am implementing 39B and C. So this is definitely, this was prone to misuse. Okay. Now both 24th Constitution Amendment and 25th Constitution Amendment were challenged in Keswananda Bharati case. This is the case which we were waiting for. This is the watershed moment, and all debates came to conclusion here. In the Keswananda Bharati case, Supreme Court gave a basic structure doctrine. The Supreme Court said that Parliament has power to amend the Constitution. The first thing was whether Parliament has the power to amend the Constitution. Yes, Parliament has the power to amend the Constitution. Does it also include the power to amend the fundamental right? Yes, it also has the power to amend the fundamental right. But in doing so, Parliament cannot change the basic structure of the Constitution. So from here, the basic structure doctrine came into existence. There is a very common question in prelims that basic structure doctrine is given in our Constitution. Is it true or false? If I give you a statement that basic structure doctrine is given in our Constitution or is written in our Constitution, is it true or false? Yes, you are right. It is false. Because this has come through a judicial pronouncement or judicial innovation. It was nowhere in our Constitution that this is the basic structure, or this is the core of our Constitution. Okay, I will tell you something very interesting about this Keswananda Bharati judgment. So, what happened that this was the Golaknath case was heard by a bench of 9 Supreme Court judges, and 11 Supreme Court judges, and this case, Keswananda Bharati, was heard by a bench of 13 judges. Okay, now at that point of time, by 1973, the Supreme Court was already divided between pro-government judges and anti-government judges. The then Prime Minister Indira Gandhi has already started talking about something called committed judiciary. There was rift between, this is something that we shall again study when we will study the appointment of judges. Okay, so at that point of time, already judges were divided. You could identify that these were the judges which were pro-government and these were the judges which were anti-government. So the first question which was there in front of these 13 judge bench was that whether Parliament has the power to amend the Constitution. Okay, because in the Golaknath case, it was said by the Supreme Court that Parliament does not have power to amend the Constitution. It is only the procedure to amend the Constitution. And here, the 6 judges which were considered pro-government, they said that yes, Parliament has the power to amend the Constitution, and there were 6 judges which were considered anti-government, they said that Parliament does not have the power to amend the constitution. There was one judge, Justice H.R. Khanna. He said that Parliament has the power to amend the constitution. So it became 6+1. The matter was settled that Parliament has power to amend the constitution. Next question came that whether this power to amend the constitution is an unlimited power. Like Parliament can amend any provision of constitution. Again, these 6 judges said that yes, this power is unlimited power to amend the constitution, and these 6 judges say that no, the power is not unlimited, the power has to be limited. Here Justice H.R. Khanna switched side. He now at this question he sided with these judges and said that no, the power of Parliament to amend the constitution is not unlimited. There are certain core principles which are there in constitution that cannot be amended. Parliament is not constituent assembly. Constituent assembly could only have, constituent assembly has a vision, it has drafted, that spirit of constitution cannot be changed. So effectively, because these 6 judges were having their rigid position, or rather these 12 judges were having their rigid position, it is Justice H.R. Khanna whose wisdom is reflected in this basic structure doctrine. And later on he also contested for the first thing happened that when it was the turn of Dr. H.R. Khanna, or Justice H.R. Khanna to become the Chief Justice of India, Mrs. Indira Gandhi did not make him Chief Justice of India. Later on, he also contested for the post of President. Obviously, he could not win election. Okay, we shall come back again on this case 1 on the Bharati and basic structure doctrine. We shall study what are the pros and cons, how it is debated. Let's first complete this evolution process. So after this, in 42nd Constitution Amendment, the Parliament tried to change the case 1 on the Bharati judgment provision. Okay. In 31C, like one more thing, all these 25th Constitution Amendment, 24th Constitution Amendment, they were also challenged. So in this case, this provision that 2 DPSPs, to implement 2 DPSP, 2 fundamental right can be violated. This was considered constitutional, that this is not violating the basic structure of constitution. Okay, this was considered constitutional by Supreme Court in this judgment. However, Supreme Court declared this part as unconstitutional, the part which declared that such an act is beyond judicial review, because in this judgment Supreme Court said the judicial review is part of basic structure. So it partially struck down the 25th Constitution Amendment Act, not completely. Okay. Also, like this part was again partially modified by the Supreme Court judgment, Article 368(1). So this amendment was also, but this part was considered constitutionally valid. So this amendment was also not completely struck down by Supreme Court. This was partially modified by the basic structure doctrine. Okay, and neither was the 25th Amendment completely struck down. Okay. And then the Parliament said that okay, you have allowed me that to implement 2 DPSPs, 2 fundamental right can be violated. The Parliament said that let's amend Article 31C and write that to implement all the DPSPs, these 2 fundamental right can be violated. Okay, so this is again a smart move made by Parliament to bypass the case 1 and the Bharati judgment. In the Minerva Mills case in 1980, this provision was also struck down on the ground that the Supreme Court said that balance between fundamental right and DPSP is part of basic structure of constitution, and this balance cannot be disturbed by any constitution amendment. So this change was struck. Now again, 42nd amendment has a lot of other provisions also. It was a mini constitution. So complete 42nd amendment act was not declared unconstitutional. Only partially one provision which was there in 31C was declared unconstitutional. Okay. Here, I mean, for prelims, it can be asked that when a court declares something unconstitutional, it doesn't mean that it is declared unconstitutional in toto. It can be partially unconstitutional as well. So, to the extent of inconsistency with constitutional provision, something becomes unconstitutional. Okay, this is called doctrine of eclipse. Okay, anything which is inconsistent with the constitutional provision becomes null and void to the extent of inconsistency. Next is IR Coelho case. In this case, that provision of 31B was challenged, and Supreme Court said that any law put in 9th schedule after Keswananda Bharati judgment, I am writing it as 1973. Okay, so any law put in 9th schedule after Keswananda Bharati judgment is subject to judicial review. So a question can be asked separately on 9th schedule as well, or merely on IR Coelho case. So the judgment is simple, that because Keswananda Bharati case said that Parliament power to amend the constitution does not include power to violate the basic structure, and judicial review is part of basic structure. So any law put in 9th schedule after Keswananda Bharati case is not beyond judicial review. It can be reviewed, but for the violation of basic structure of constitution. Is it clear? If you have any doubt, any confusion, you must ask. Have you noted it? All the provisions that I taught? All of you who are online, please like the video. Liking should be the first thing that you should do. As soon as you tune in, the first you should press the like button and give regards to your teacher. It's like that first we say good morning, good afternoon. Similarly on YouTube, first you say like. Okay. So now we got basic structure doctrine. So we shall write some proper. Yeah. Okay. Yogesh is learning very fast. He has done it already before starting the lecture. Yeah, I was happy today that there were 2 likes even before I had started. Good. So if I have to ask you what is basic structure doctrine, this is the proper definition of basic structure doctrine. That certain fundamental features of the Constitution of India are inviolable and cannot be altered or destroyed through amendments by the Parliament. This is the basic structure doctrine. Obviously, it was given in Keswananda Bharati versus State of Kerala case 1970. Now, the next question that can be asked is, what are the positive impact of Keswananda Bharati case? Can you tell me? How has this case impacted the constitution amendment jurisprudence in our country? the way constitution is amended or the way legal system works in our country, how has that changed in a positive way? Any point, at least one point every one of you should write. I'm waiting for your answer. The first and foremost thing, it protected the spirit of constitution. Something which we are calling as basic structure. Basic structure is that the spirit of constitution is protected. And the second thing that you can say, that it declared that parliament has limited power. So rather you can say it limited the power of parliament. Now from this aspect we can derive two different conclusions. One is that it made constitution supreme. That constitution is the supreme document. Otherwise parliament would have become supreme. If it had the power to amend the way it wanted, effectively parliament would have become supreme. But this doctrine made sure that the spirit of our constitution is protected, and in a way constitution remains supreme, not the parliament. And it also gave primacy to aspect like separation of power, judicial review, etc. And this made sure, like separation of power is also declared basic structure, judicial review is also declared basic structure, that cannot be inviolated. So the parliament, it also ensured the balance between different organs of the state, or it rather maintained the balance between different organs of the state. It was not possible that parliament could usurp all the powers from other organ of the state like judiciary and executive. Okay, yes, you can say check and balance. It maintained the check and balance, of which I am telling as balance between different organs of the state were maintained. Okay, or in a way you can say that it strengthened the judiciary. All the talk about that committed judiciary, everything that went away by this judgment. It says that now it put judiciary firmly on the position to protect the fundamental rights of the people and to protect the spirit of the constitution. It put responsibility on the judiciary that you have to protect the spirit of the constitution. Okay, so we need to understand both things. Obviously we will also study the criticism has already been asked by UPSC in probably in 2013 itself. UPSC asked the criticism of this basic structure doctrine, but with apart from the criticism we should also know the positive aspect of it. Now you tell me what are the criticism, but before writing the criticism, let's first write what are the items that have been declared as part of basic structure. Okay, you must be knowing already. I have given you a few examples. Do take a note of all these examples along with the respective judgment. Judgment is also important. It may take you some time. This will take you some revision. Revise it 2 or 3 times. Judgments are as important as the provision. So both the things you must remember. See, supremacy of constitution. Keswananda Bharati case itself said. Principle of separation of power. Keswananda Bharati itself. Sovereign democratic republic nature of our constitution. Keswananda Bharati case. Mandate to build a welfare state. So India cannot become a police state or laissez-faire state under this current constitution, because Supreme Court has said that Indian government has got a mandate to build a welfare state. Okay, and then unity and integrity of the nation. One more thing, this is something that I will tell you in the criticism part. The very fact that certain different judgments are mentioning different items which are there in the basic structure, it means that Supreme Court did not declare a list of items which are part of basic structure. I will come to that. So first note down these items. In this Indira Nehru Gandhi versus Raj Narayan case, see, this was also an interesting case. When in 1975 the election of Indira Gandhi was declared unconstitutional, then this 38th Constitution Amendment Act was brought in 1975. In this, it was written that the election of President, Vice President, Prime Minister and the Speaker cannot be questioned in a court of law. It was the election of these constitutional offices were kept out of the purview of judicial review through 38th Constitution Amendment. The Supreme Court says that free and fair election is part of basic structure. So no constitution amendment can take away this part. And also judicial review was part of basic structure. So this amendment was also declared unconstitutional. In this judgment itself, rule of law was declared part of basic structure. So again, you can see rule of law is as such explicitly nowhere written in our constitution, but it is implicitly part of Article 14. So even something which is implicit has been declared as part of basic structure. Okay. In S.R. Bomai versus Union of India case, what do you know about this case? S.R. Bomai case, secularism as well as federalism. Yeah, S.R. Bomai case also declared federalism, judicial review, social justice as part of basic structure. Okay, this case was about a state emergency, or which we known as president rule. Then this L. Chandrakumar versus Union of India case 1997, judicial review is also there with High Court. This was declared as part of basic structure. So in this case, the power or rather the jurisdiction of high courts which were removed from the tribunals, like it was mentioned that an appeal from tribunals would be directly lying to the Supreme Court. That aspect was declared unconstitutional. Okay, have you noted down all these different examples? Now we shall study what are the criticism. Tell me, what is the criticism of this doctrine? Any idea, anything that comes to your mind? Yes, it is not written in the constitution. Yes, anything else? It is not defined. Yes, it is not explicitly defined that what all will be included. It has been left to the wisdom of the judges. Tomorrow a judge can think that okay, the Supreme Court in Delhi is part of basic structure. So it is open to subjective interpretation what constitutes the basic structure of our constitution. Okay, and it gives immense power to judiciary. Ultimately, see, a constitution amendment is done. Whether that constitution amendment is constitutionally valid or not, who is going to decide? Judiciary. So judiciary has got the upper hand or is now the final interpreter what kind of constitution should be there. Okay. Now see, India is a democracy. In a democracy, ultimately, who should decide what kind of constitution should be? It should be the people of India. In a democracy, the people are supreme and the representative of people are there in parliament, not in judiciary. Parliament represents the will of the people. Parliament represents the will of the people. So ultimately, the kind of constitution people want to give to themselves should have been decided by the parliament, not by the judiciary. Judiciary is a body of, not an elected body. Rather, judiciary is a body of, what do you say, bureaucrats. Judiciary is not an elected body. It is a body of experts, or rather it is a bureaucratic body. And in a democracy, elected people should have primacy, not the expert people, not the official. Rather, this is a body of officials. So if at all there should be supremacy of someone in a democracy, it should be elected people, not the appointed people. Body of officials, it's a appointed body. And the next problem is also, see, when a constitution amendment is done, it is done through a special majority in parliament, that too in both houses of parliament. But look at the Keswanand Bharti case. It was decided by a very thin majority, 7:6. It was not that there is a requirement of special majority. And in future also, if any judgment or if any constitution amendment is to be declared invalid in Supreme Court, it is only the majority of judges on any bench who shall be deciding. The first thing, that it is the officials, it is the appointed people who are deciding. Second, that unlike parliament, they are deciding by simple majority. So it's not that there is a consensus in Supreme Court either about this judgment, but it is being implemented. Okay. And then some other aspect we can write that this is an example of judicial overreach. Judiciary has gone into the domain of parliament. See, constitution did not give the power to amend the constitution to the judiciary, but effectively from parliament, judiciary has taken away the power of amending the constitution to itself. This is an example of judicial overreach. Next is, it is undemocratic in principle. Next point, there is lack of clear definition as to what constitutes the basic structure, and this lack of clear definition brings about ambiguity and uncertainty. Like even parliament is not sure what kind of amendment would be accepted as per the basic structure and what would not be accepted. This also makes the constitution inorganic. Our constitution maker wanted our constitution to be organic. That's why they neither made our constitution very rigid nor they made it very flexible. Like unlike US constitution, which is very rigid in nature, there has been only 27 amendments so far in US constitution. Our constitution has already witnessed around 105 constitution amendments. So our constitution maker wanted the constitution to be organic, whereas this doctrine will make it inorganic. Okay. And it will also retard the legislative innovation, because legislature will not be taking risk to amend the constitution. Any aspect which will come, like which will require the amendment of constitution, the legislature will see that may be or may not be. For example, like there is a consensus that judicial appointment process, this collegium process is not perfect. There is a need to change this process. There should be some role of executive and legislature. Judiciary should not be appointing judges, but still the parliament is not enacting any law. Why? Because NJAC was declared unconstitutional on the ground of violation of basic structure. And this is also an impediment to social justice. Why this all debate about whether parliament can amend or not went to the Supreme Court? Because parliament wanted to implement the social justice. So in a way, this is also being seen as impediment to social justice. Let's see what is the doubt. Yogesh is saying, sir, in real judiciary is one who is protecting democracy against arbitrary action of parliament. Okay, Mr. Bhawel is saying, sir, constitution organic or inorganic को explain कर दीजिए. Okay, first I will explain what this organic and organic. The organic has come from the aspect that the living organism, they are considered organic. They grow with time. So our constitution maker also wanted our constitution to be a living document that will grow over time, that will evolve over time, that can change over time. Okay. Inorganic is something that does not grow with time, that remain as it is. So if the amendment to constitution is not permissible, the constitution would become inorganic. Or the very fact that we are saying that most of the feature are going to be part of basic feature that cannot be changed. So in a way, our constitution will become inorganic, which is against the wishes of our constitution maker. Okay, is it clear? Now the point is what Yogesh is saying, that yes, theoretically, what you are saying is right. So theoretically, this is anti-democratic. This is against the wishes of our constitution. But practically, this doctrine has done a lot of good. Practically, it has protected the spirit of our. Practically, the debate between parliament and power to amend the constitution or not has been settled after this. The fundamental rights of people has been practically protected because of this doctrine. So there is a consensus among the judicial or the consensus among the legal fraternity that this doctrine has been a great boon to our constitution, or rather our constitution has been protected because of this doctrine. And to answer this criticism, the Supreme Court, this doctrine has only partially invalidated six constitution amendments. And there has been only one instance of complete invalidation. And that was this NJAC case. So there has been only 7 instances in the history of India that a Constitution Amendment Act has been declared invalid by Supreme Court. And out of those 7 instances, there has been only one instance where the complete Constitution Amendment was declared invalid. Only in rest of the 6 cases, the Constitution Amendment was declared partially invalid. Like we have seen in 42nd, we have seen in 24th, 25th. So, Supreme Court has been very cautiously implementing this doctrine. The Supreme Court is not throttling the power of Parliament, or Supreme Court is not trying to make the Constitution inorganic. Only when there is a threat to democracy, when free and fair election is being compromised, this doctrine has been used. So in the conclusion, you will write that from the way the doctrine has been implemented, it is being considered as a boon for Indian democracy and Indian constitution. Has it been the case the Supreme Court has taken away the power of Parliament and it is invalidating one after another all the constitution amendment, then we could have said that probably the Supreme Court has become too powerful. It has become something like there is a line, I'm not able to recall it. If it comes to my mind, I will tell you. There's a quotation which is there that something becomes a imperio in imperium. There is this line. Imperio in emporium. Imperium. It means that an empire within an empire. So there is an empire, that there is a state called India. Within that state, Supreme Court has become an empire in itself. This is something, a criticism which is leveled against the Supreme Court, that when you have given the basic structure doctrine, when you have said the judicial review is part of basic structure, when you are saying that judiciary independence of judiciary is part of basic structure, now judiciary will do its own appointment. In effect, you have declared, in effect, Supreme Court has become imperio in imperium, an empire within an empire. So we say that the data does not support this fact. The data says that Supreme Court has been using it very sparingly, cautiously, only when the democracy is in danger. So in effect, the way it has been used, it is boon to our democracy. This is what you are going to conclude. Is there any doubt? Then we shall move towards next topic, emergency. This is again a static topic. I am going to take you very quickly through this topic. Okay. The first thing is national emergency. The question, okay. So the question in emergency that can be asked is going to be about not a static provision, that what is the provisions, although it has been asked about such things are often asked, like once we have had a question about financial emergency. So such things can be asked. But still, what I am expecting is that the question they are going to ask is that how has 44th Constitution Amendment changed the way, changed the emergency provision in our Constitution. So we shall see what were the Constitution provision. So original Constitution has a provision that on the grounds of war, external aggression and internal disturbances, emergency can be imposed. So there are three grounds which were mentioned. This third ground, internal disturbances, have been changed to armed rebellion by 44th Constitution Amendment, because the emergency which was imposed in 1975 was on the ground of internal disturbance, which was very much misused. Next is that original Constitution was simply mentioning the president can proclaim emergency. Here it was added that on written advice of cabinet, president can proclaim emergency. So this word cabinet was introduced in our Constitution for the first time. Apart from this place, nowhere in our Constitution word cabinet is mentioned. Okay. Next is, earlier this provision of approval by a special majority and within 1 month period. So time period originally given was 2 months. Originally there was a requirement of simple majority. This was changed to a special majority by 44th Constitution Amendment. Can you tell me the logic why we have a special majority here, not simple majority? The logic is, see, to make a constitution amendment, you require a special majority. And the effect of an emergency is very much similar to constitution amendment. The constitution turns unitary from a federal structure after an emergency is proclaimed. Fundamental rights of people are taken away when emergency is proclaimed. So when it has the effect similar to constitution amendment, the process should also involve similar to constitution amendment. So that's why this a special majority in both the houses sitting separately was introduced. And then this provision of regular approval every 6 months was also introduced by 44th Constitution Amendment. And the period continues to be indefinite, subject to periodic approval. So what is the maximum time limit for which an emergency can remain in force? The answer is indefinite. There is no time period. But every 6 months it must be approved by both houses of parliament. Okay. Next is what is going to be the effect. The effect of national emergency we shall study under two heads. One is like the effect on federal structure. Federal structure. Parliament becomes empowered to legislate on a state list. Normally on a state list, parliament cannot make a law, but during emergency it can. And such a law remains valid for, what is the validity of such a law made during emergency on a state list? It remains valid for 6 months after emergency ceases. So after emergency comes to an end, the act will remain valid for further 6 months. Okay, those acts which parliament were not empowered to or make a law on. Okay, center can issue direction to the states on any matter. Then president can alter the revenue distribution. So financial, executive and legislative. There are three domains in which we study the center-state relation. In legislative domain also, the item becomes unitary. In executive domain, center can issue direction, and financial domain also, president can alter the revenue distribution. The same three dimensional structure we shall study again when we shall study the center-state relation. So keep this in mind. Center-state relation is from three perspectives: legislative, executive and financial. Fundamental rights have been segregated in two parts. One is Article 358. This is also important. Article number you should memorize. And one more thing that I have told you. In case you come across any article of Constitution, it should be your duty that after the class you go, you open the bare text of Constitution, read the article, what exactly is written. And the day when you are able to understand these articles on your own, that is the day when you can declare that now you have developed command over polity. Okay. So Article 58 says that Article 19 would be automatically suspended, whereas Article 359 says that the other fundamental right can also be suspended if it is mentioned in the proclamation. So the proclamation which declares the emergency, if the president declares that any of the other fundamental rights are suspended, then they would be suspended, and that is mentioned in Article 359. There is no automatic suspension. Here there is word automatic suspension. If an emergency is declared, this is automatically suspended. But this is something also introduced by 44th Constitution Amendment Act, that Article 20 and 21 can't be suspended. This provision was not there earlier. And out of the three ground, there was war, external aggression and armed rebellion. Article 358 or other Article 9 can be suspended only on the ground of war and external aggression. It cannot be suspended if emergency is proclaimed on the ground of armed rebellion. I repeat, if emergency is proclaimed on the ground of armed rebellion, then Article 19 would not be suspended. Only if emergency is proclaimed on either war or external aggression ground, then Article 19 would be suspended. Okay, so right now Manipur fulfill the conditions for emergency. Still, why it is not? See, it is not being said now that if there is an emergency situation, the emergency has to be declared. Like the government, it has to be the judgment of the government. The judgment today feels that it does not need those powers to control the situation in Manipur. So I mean, it is not necessary that if you have the power, you have to use it. For example, if you have the gun, it is not necessary that you will use it. Sometimes you can decide that I will talk first, then I will use the gun. Okay. So these are the constitutional provision. Apart from these provisions, there is also an aspect that the life of Lok Sabha and State Legislative Assembly, the life of Lok Sabha and State Legislative Assembly can also be extended by an year. At a time. So during emergency, like it may not be possible to have election, conduct election. So for that also there is a provision that the life of the Lok Sabha or State Legislative Assembly can be extended, further extended. Okay. The last aspect of today's class is financial emergency. Rather, we do not have much time, so I shall start this financial emergency chapter in the next class. At the beginning of the next class, I will start this financial emergency, or you can study it on your own also. I will very briefly cover it because from 4 p.m. we have DNA analysis that is to be covered, in which we cover the daily news analysis. Some of the important news from the daily newspaper is taken up and it is discussed in detail. So you may go and watch the DNA analysis. We have to close this class here. We shall see you again after Dasara now on Monday from 2 p.m. afternoon. We will again have the next class. See you again. Happy Dasara. I wish you enjoy the happy Dasara. My advice would be to stay away from the crowded places because crowd management, in my opinion, is not very good in India. So during Dasara, I would request you to stay away from those crowded places, be safe and enjoy it. Happy Dasara.